Hello, everybody. Welcome to another episode of This Week Unloaded. I am your host, Rich White, and with us so far on the panel, we have Mr. DM Foss. How are you tonight, sir?
I'm doing all right.
Sorry, I felt like I was going to sneeze. You know how you get that feeling, you feel like you're going to sneeze, and all of a sudden it just goes away? Anyway. California, they got their steel on in Los Angeles. I don't know if you saw that or not. Miraculously, overnight, the person who conceded the race on Tuesday took second place in their mayoral election. Since their primaries are everybody lumped into one primary, what's his name? Spencer Pratt is no longer going to win or be capable of making it into the November election because they throw everybody into one pot. You know, I have a story pulled up on X about that. She conveniently got the majority of the mail-in votes overnight, and that allowed her to take second place. Again, this is after she had already conceded and said she lost. Why? Because California law allows votes to be counted up to 10 days after the election. In other words, as more ballots come in, they can keep counting them 10 days after election day. That's kind of suspect. What do you think?
Okay.
They don't stop counting ballots just because they come in after election day, basically. So, say election day is Tuesday, June. What was this past Tuesday? The 4th, something like that. No, this past was the 2nd. So, say election day is Tuesday, June 2nd. Any ballot after that shouldn't be counted, but they can count them all the way up to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. This coming Friday under California law.
As long as they were cast on time.
That's just it. They're talking about ballots that were never received until after the 2nd. Talking about ballots that weren't received on time.
Well, if they're mail-in, as long as they were mailed before.
Yeah, that's what I'm saying. It doesn't matter when the postmark is. As long as it's received within that 10-day period, they can count them.
Oh, yeah.
Yeah, it's kind of crazy. Something just fell. Packard says they're still counting ballots for Reagan. I don't think they're counting that long ago. It was, what, 46 years ago? Man. But yeah, just thought I'd start with that story in case Gizzard's running late before we get into the main story. An interesting one out of.
He's in Nebraska.
No, he's not. He didn't go.
Oh, he didn't?
Nope. He
What?
decided that he wasn't going.
What a slacker.
Hmm. Yeah, he told us he wasn't. It was either Wednesday night on his members only or on at their Guns and Barbecues show that he wasn't going. He originally he was, but he changed his mind. I don't know if you heard that outside, but somebody is not happy with somebody. Okay then. The joys of living in the city. Yeah, he decided he wasn't going to go, so even if he did go, he'd have been home by now anyway, by his own reckoning.
Oh, that's right.
Yeah, yeah. I just saw that one pop up on Instagram on X, and thought that was kind of funny that should happen. She was getting, like I said, she was getting beat so badly that she had already conceded the election, and then in one night she got enough votes to take second place.
I don't really know any of them, but from the little bit that I heard, Bass is kind of a liberal, and Pratt was way farther left.
No, Pratt's the right wing guy.
Oh, is he?
Yeah,
I
the
I
other
don't know.
one's the
Maybe.
left wing. Bass and the other woman are both left wing.
Oh, I probably mixed them up then. There.
Yeah. Yeah, Spencer Pratt was the former actor who ran because he's one of the victims of the fire whose house has not been able to be rebuilt yet, and he's angry over that. And he had all kinds of crazy, silly commercials that he was doing, and he had a really big following. So I'm not surprised that this would happen in a late night mail drop all of a sudden. To be perfectly honest, but yeah, he was projected to take second place. And as of election day, he had. It's the funny way that she all of a sudden just shot up, kind of reminiscent of when that happened with somebody else back in 2020. Yeah, they're calling it the Eric Doherty. He's a independent journalist who posts on X, and he's saying it's a magical late male performance, which, yeah, like I said, the woman had already conceded that she lost. And then this happens. And like he even says there, they need to outlaw the election month, outlaw late mail in ballots, and require universal voter ID and citizenship. It's awful suspicious the way this happened in California within their deadline of when even after election day things could still be counted. It's insane. It's insane that in this country, as a national law, we don't have voter ID. You look at almost every other civilized, advanced country in this on the planet, and they require photo ID for voting. Even in countries that people are sneaking into this country from, they need photo ID to vote in. Like Mexico, I believe Mexico, you need to have a voter ID. You have to have a photo ID to vote. Canada, I believe you need photo ID to vote. England, I know you need photo ID to vote. I mean, it's some reason We don't. And that failed this week in the Senate. You had 4 Republicans cross over and vote with the Democrats to say no to it, even being added to a bill. They were going to try and put it on the recent reconciliation bill, and 4 Republicans, I forget who, crossed over. I think one of them was Susan Collins out of Maine, and the other one was the woman out of Alaska. What's her name? Murkowski, I think was her name. I'm pretty sure those two were two of them. I forget who the other two were. But 4 Republicans crossed over with the Democrats and killed it. Now, speaking of Gizzard Gary, how are you tonight, sir?
Can you hear me?
Yep, can hear you.
Doing all right. How are you?
All right.
I
Got a little.
heard you out talking about me, so I figured I better get in here and defend myself.
Yeah. Yeah, Foss was still thinking that you weren't in Nebraska, so I had to fill him in
If
that you decided.
I'd be home by now.
Yeah, that's what I said. He'd be home then anyway if he went.
Yep, I would.
So you've been listening then. So what do you think about the situation in L.A.?
I think it's bullshit.
Mm,
But what can you do? It's California.
yeah.
Everything there is bullshit.
Well, I saw another post where the DOJ is planning to investigate as well. So this might not be over.
We could just invade California, but then we'd have to take care of it.
Mm-hmm.
I will almost guarantee nothing will come of that investigation.
It's not likely, but you never know. The fact that they even have to investigate it is bad enough.
Let's give California to Canada. I like that idea.
I would say no, be- mainly because if California was its own country, it would be the 10th richest country in the world. That's a lot of economy to lose.
Well, I want to get something in. I want to get something in return. Um, Alberta. Let's see.
Alberta would work because there's a lot of oil production in that
Yeah,
province. And we'll take British Columbia except for the immediate Vancouver area. There's some pretty country up in British Columbia. Think we can get Manitoba thrown in too? Or would that be pushing it?
just so we don't get Quebec in the deal. I don't want Quebec.
No, nobody wants Quebec. Or Ontario. They can keep both Quebec and Ontario.
Oh, what is it? Saskatchewan has the crops, so it's a
Mm-hmm. Yeah, Saskatchewan and Manitoba both have farming, and then Manitoba into Alberta, you have oil fields and fossil fields too. A lot big for anybody that's into that kind of stuff. Big fossil fields of dinosaurs and stuff.
you got to make Black Cat excited.
Mm-hmm. Mm-hmm.
So you're saying dinosaurs are real?
Well, there's definitely something.
Once again, I say no one has ever seen a dinosaur bone.
Oh, I've seen stone. that looks like a dinosaur bone. But one thing that they have seen from that era are insects that are trapped in amber, allegedly. Well,
Amber Heard.
no, not amber heard. The stone that's formed from fossilized tree sap or other types of sap. Bugs got caught in that, and then it turned into stone, and the bug is trapped in the stone, and because it's sealed in that stuff, the things that caused decay couldn't get to it. That was the whole premise behind Jurassic Park. If you remember, the old guy had the amber stone in his his walking stick and had a mosquito in it. Or
Yeah, well, what he said it wasn't what it was.
no,
And you have to be careful. There's a lot of fakes coming out of China.
yeah, that's not hard to fake. Basically, it's got to cook the amber, and it'll or the tree sap, and it'll turn to amber like that. Get this off the screen. Stop sharing that. And we'll share this one. But anyway, our top story tonight is a interesting Fourth Amendment case out of Maryland that also affects the Second Amendment in that state. So you guys ready to dive into this?
What do we have to do to be ready?
Just be here, I suppose.
I have to take my pants off.
We had to wear pants. I didn't know that.
As long as your camera's not on, clothing is optional. Let's see. Well, first we'll say hello to the people out there on the YouTube side. We got first Ron 2A Matters, and Pack Rat's Attic, and Denny's Plant-Based Journey, and let's see, is there anybody else out there? And DM Foss is out there and in here. So yeah, that's what I'm seeing out there in the YouTube side. X probably didn't have anybody saying anything. Did it start playing on X? Yes. Nope, nobody on X. And Rumble says we have one, but Rumble always says there's one. Yeah, everybody's showing up in the chats as being on YouTube, so there's a Grim Reaper Reviews, aka Justin Grim, so evening to you, sir. And Denny says he watched Spider Noir. He said it was a great series. He said hopes they come up with season 2.
I thought it was good, not great. It would have been a lot better if Cage was 10 years younger. He's kind of old.
Mm-hmm.
But I did enjoy it. I watched it in the color. I'm going to go back and watch it in black and white.
Yeah, I watched half an episode in color and was like, no, it's better in black and white. So I went back to watch it in black and white. you get more of the what's the word I'm looking, ambiance when you watch it in black and white. It gives it more of that the feel of what they were going for with the whole wanting it to be like a film noir type thing. You know what I
Well,
mean?
they there were spurts of dialogue that were really good, fast paced back and forth. A lot like the movies of that era. But
Hmm.
then Cage would throw in his kind of cageism, and it would kind of it would break that. It kind of take you out of it. At least for me, it did.
As
But
far as the, oh, good.
I was to say, like I said, I did enjoy it.
As far as his age, I mean, if you look at the flashbacks to World War One, even then he looked like it would have been in his 30s, and he was a sergeant in those scenes. So yeah, maybe 5, 10 years younger would have been better, but I didn't see the age as big of a issue because of the fact of how old they were showing him as being during World War One, and this was the late 30s. I mean, early 30s when this was happening. So you're still looking at like a 20-year gap between World War One and when the movie was taking place. So yeah, I can see what you're saying about maybe 5 to 10 years younger, but yeah,
I mean, there's nothing they can do about it now.
right.
And I don't know if you saw the comment I left on last
No,
week's episode.
the only comment I saw was from Patriot in the Dark. And
Um,
I even checked today, so I don't know if your comment's just not showing up or what, if you left one.
I know you didn't mean it this way, but the way it sounded was the actress did such a good job, you don't even realize she's Asian.
Yeah, it was not meant to sound as a racial thing. If that's so,
I,
no,
I,
if it
I,
came across that way,
Wow.
I apologize.
Wow.
I yeah, I knew that's not what you meant, but that is absolutely the way it sounded. And then I commented on the McDonald's coffee. Um, it gets told as a joke, but McDonald's was warned several times that the coffee was too hot, and the old lady that got burned, she got third-degree burns and was in the hospital. And all she was all she asked for was her medical bills, and McDonald's said no. And the way that McDonald's fought it was to put out the story that, oh, she got burned because she didn't know hot coffee was hot.
Hmm.
Well, that's not what happened.
Okay, let's retroactively remove that one, and instead the woman who tripped over her own child who was misbehaving in a Walmart and won $1 million lawsuit against Walmart. There's still frivolous lawsuits in any way you want to slice it.
Well, yes, I know, and that it just kind of it bugs me the way the McDonald's one is misrepresented. And I'm not saying you did it purposefully,
No, that's always
but
like whenever somebody says frivolous lawsuits because of what you just said, that's the first one that pops in people's minds. It always seems like that's the first one people think of is the somebody suing McDonald's because they spilled hot coffee on themselves. Whether that's accurate or not, that's the first thing that pops in people's minds because, like you said, the campaign that McDonald's put on, which goes to, I guess, saying something about their PR department and how good a job they did in trying to turn public opinion against the woman suing McDonald's. When you think frivolous lawsuits, that's the first one that pops into your head. Didn't that case even win the Darwin Award or something too? So I mean, it there's a reason why that's the first thing that pops in people's heads. But, we've got Guns and Barbecue out there complaining about Rumble as usual, and Jacob S is out there. So evening, Jacob. And getting back to Spider Noir, then he said there are some really good parts, there were some weak parts, but he really liked it. Doesn't normally watch TV unless it's sports. I think they can do a season 2 and find out there are more men. Yeah, I got a feeling that's what they're going to do with season 2. Is you're going to find out that there's more of these guys, because there's a lot more Spider-Man villains that weren't in that season.
It was kind of interesting. They didn't end it on a cliffhanger to set up a second season.
Yeah, which is refreshing in and of itself, because how many times have we seen a show end on a cliffhanger and then not get that next season? So you're sat there with this cliffhanger, not knowing what happened. You know what I mean? So that was kind of nice not to have it end on a cliffhanger.
Well, I liked the way they ended it, where the chick tries to reconcile with Cage's character, and he basically rebuffs her, and then she slaps him and walks off.
Yeah, her and her boyfriend. Going into his identity would probably be a spoiler, so I'm not going to do that. You've seen it, so you know who I'm talking about.
Yeah, but that does a few things. It breaks the tie between the two, so she's free to move on,
right?
And it helps kind of solidify his character as the Humphrey Bogart type.
Yeah. Kind of reminiscent of the end of the Maltese Falcon, where he doesn't want to, but Humphrey Bogart's character of Sam Spade turns in his would-be girlfriend because she broke the law. It has that same kind of feel to it, where you get closure on that.
And I haven't read any of the comics, so I don't know anything about that side. I only know the TV show.
I haven't read the Spider-Man Noir comic either, so. And then he says the secretary is probably the best character in the show, along with Silvermane. He thought they had quite a few characters who were pretty important roles and pulled it off well. It wasn't just 2 or 3 people. No, there was a very good cast. And you end up liking a lot of the characters, I think. I liked Silvermane. Silvermane, even though he was the big bad villain, came across as somebody you could still sit down and have a drink with at the bar. Like you see Nicolas Cage is character him too.
He was probably out of every character, he was like the most real.
Yeah.
He wasn't over the top evil. I mean, he was a bad guy, but he would kind of explain why he's doing what he's doing, and it made sense why he was doing what he was doing.
Yeah. And his reaction to the laboratory was extremely human. Whereas a lot of times in comic books, you'll see the villain, who cares? He had a more human reaction to what they were seeing. The guy who played Silvermane did a very good job playing that part.
Yeah. I'll say I didn't really like the secretary.
Oh, I like the secretary, especially the
Was-
interactions with the secretary and the little kid towards the end of the
that
series.
was good. I thought they did a good job with that. I just found her a little annoying.
And that kid throughout the whole season was good too.
Yeah, he did a really good job.
Yeah. Then he says, "Yeah, he seemed stable and in control. He knew a guy very similar to him in real life, without the wickedness, but very powerful and decisive, but understanding." Yeah. Then he also says the kid was good.
I thought the reporter he did a good
Hmm.
job.
Yeah, yeah. The guy that played Robbie Robertson. Yeah, he did a
Yeah,
really good job. Heck, they could have him play Robbie in one of the Spider-Man movies, and I think he would pull that off as well in a more modern Spider-Man setting. Then he said he pulled off the accent. I believe the actor who played Silvermane is from Ireland, if I'm not mistaken, because he's played Irish people in things before.
I think so. I think that is his normal accent.
Because he was in oh, Gangs of New York and a couple other things where he played an Irish person. So I think he is from Ireland. Then he says, "Yeah, and him getting screwed by the newspaper editor was very real, especially in that time with racial tensions." Hmm. And they changed the name of the newspaper editor too, from J. Jonah Jameson, and I'm wondering if that's part of the contract issue that they had, where Sony couldn't use a lot of the actual names because of the level of violence in the smoking and drinking and all that touched on before. Oh, he said no. He meant the kid pulled off the gangster language very well. Yeah, yeah, yeah. They did a really good job coaching the kid and getting him ready for that part. And the little subtle things, like how he was Nicolas Cage's lookout, and the way they had him sending the messages through sign and stuff, was really good too. They did a really good job coaching that kid for to play that part. All right, are we done talking about Spider Noir now,
Sure,
or you
Chad.
got anything else you want to add before we go on to the other?
Yeah, Gleason is Irish.
Okay, so I guess we can move on to the main story. Because this, as if you read the title, comes out of Maryland, the Appellate Court for the state, their intermediate appellate division, right below their state Supreme Court. It's the case of Stephen Hicks versus State of Maryland, number 634, heard back in September of 2024, and they just now gave the opinion on it. Opinion by Graff, I'm guessing is how you pronounce that. J. Fourth Amendment, reasonable suspicion, Terry stop. Second Amendment, Terry frisk. This is just the summary, and then the actual decision comes after the summary. This is from their website, the Maryland Court of Appeals website. If you want, the link to it is down in the description. So if you want to follow along yourself, you can go down there and click on that, and that'll take you to this page. If anybody's wondering, I have dark mode on because it's easier for me to read when it's white writing on black background. Anyway. In New York State Rifle and Pistol Association, Inc. versus Bruin, 597 U.S. 1.10, 2022, the United States Supreme Court substantially changed the legal landscape with its holding that the Second and 14th Amendments to the United States Constitution protect an individual's right to carry a handgun for self-defense outside the home. This ruling, among other things, changes the analysis for whether possession of a gun justifies an investigatory stop under the Fourth Amendment. Although the Maryland appellate courts have, for decades, upheld police stops based on reasonable suspicion that a person is in possession of a gun, after Bruin, carrying a handgun publicly for self-defense is presumptively lawful, and therefore mere possession of a concealed firearm by itself is not indicative of criminal activity. The mere possibility that a person with a gun might not have a valid license or otherwise may be restricted from possessing a gun is not enough to establish reasonable suspicion for a seizure. The police must have reasonable suspicion that the person is possessing the gun illegally or otherwise engaged in criminal activity. Because the officers here stopped Appellate based solely on his possession of a gun without reasonable suspicion that he was possessing the gun illegally or otherwise involved in criminal activity, they did not have reasonable suspicion to stop him. We reject Appellant's claim that under Bruin, an officer may not conduct a Terry frisk for officer safety when a suspect lawfully stopped is armed. Because a gun is a dangerous weapon, officers may frisk a suspect carrying a gun regardless of whether the suspect is carrying the gun legally or illegally. There is no dispute here that Appellant was armed with a handgun. Had there been a proper stop, the police had reasonable suspicion to frisk Appellant. The police also exceeded the scope of a Terry frisk by reaching into Appellant's bag and pockets. A Terry frisk is limited to a pat-down of outer clothing unless the police show that a pat-down would be insufficient to determine whether a suspect was armed and dangerous. The state did not make that showing here. Moreover, the state failed to meet its burden of proving that the plain view and plain field doctrines applied to justify the seizure of drugs and gun. The officer who conducted the pat-down and found the second gun and drugs did not testify, and there was no evidence regarding what that officer observed in the bag prior to reaching inside. There also was no testimony that, based on what the officer felt during the pat-down, it was immediately apparent to him that the appellant's pocket contained contraband. The stop and frisk were unconstitutional. The court erred in denying the motion to suppress. Any thoughts on this so far?
No.
Gizzard?
Nope. Nope.
Okay. The original case was in the Circuit Court for Baltimore City, case number 123209008. Reported. Why is that word important? Well, let's go over here real quick to the Maryland court's website. Why is that being reported important? All of the court's opinions are issued in writing. Some are also reported, which means that they are published in the bound volumes of the Maryland Appellate Reporter, and unless overturned by the Supreme Court, serve as precedent that binds the state's trial courts. What does that mean? That means that unless the state appeals this to the Supreme Court, in Maryland, they cannot stop you just on suspicion that you're carrying a firearm anymore. Even if they see you with the firearm, they cannot just assume that you're carrying it illegally. You have to be stopped for something else. And this is an en banc decision from the appellate, so there is no case here where this was just to a 3-member panel or some such like we see in a lot of cases. This is an en banc case, and it goes through the list of all the justices in the Maryland Appellate Court, and then it gives you who was involved in this opinion. The
Did it
opinion
go
again,
banc?
go,
Go 3-panel first and then en banc.
yeah, this is the en banc decision.
But that's what I'm asking. Did it go to a 3-panel first, or
I
did
don't
it?
know if it. I don't know if it did or not, but I know that all I know is that this is the en banc decision, and I believe there was 7 members involved. 1, 2, 3, 4, 5, 6. Yeah, 7 justices of the list that you saw up here that gave the opinion. You got the main opinion by Groff J, joint concurring opinion by Berger, Friedman, and Shaw JJ, concurring opinion by Nazarian J, concurring opinion by Lehi J, and concurring opinion by Friedman J. It says it doesn't say there's any opinions in dispute. This means that the en banc panel of judges that heard this all concurred on the decision. So it's a unanimous decision. And the final ruling was filed on the 4th of June, 2026. And then we get into the main ruling. This is a few pages long, so we're gonna, where were we? Okay. Stephen Hicks, appellant, was indicted in the circuit court for Baltimore City with multiple drug and firearms offenses. He filed a motion to suppress the 2 handguns and cocaine discovered during a warrantless search of his person and bag. He argued, among other things, that the officers did not have either probable cause or reasonable suspicion to stop or frisk him because he had a permit to carry the weapons at issue. After the court denied the motion, appellant then entered a conditional guilty plea to possession of a firearm with a nexus to a drug trafficking crime. The court sentenced him to 5 years of incarceration without the possibility of parole. On appeal, appellant presents 2 questions for this court's review, which we have consolidated and rephrased as follows. Did the circuit court err in denying appellant's motion to suppress evidence recovered during a warrantless search of his person and crossbody bag? For the reasons set forth below, we shall reverse the judgment of the circuit court. And here's the question. It gives what the 2 questions were that the appellant presented in light of New York State Rifle and Pistol Association, Inc. v. Bruin, 597. Yeah, I already went through that. May police arrest or conduct a Terry stop or pat down of the individual based solely on his carrying a holstered handgun, where he immediately asserts that he had a license to carry the gun without first allowing him to produce a license. 2, assuming arguendo that this court determines the appellant was not arrested and that a Terry stop and frisk were warranted. A, did the police exceed the scope of the pat-down search by putting their hands in appellant's pockets and crossbody bag? And B, did the state present evidence to justify the search of appellant's pocket and bag without calling the officers who removed the evidence to testify at the suppression hearing? So those are the original questions that the court summarized. Factual and procedural background. On July 5th, 2023, Detective Mitchell Ramsey, a member of the Group Violence Unit of the Baltimore City Police Department, was a passenger in an unmarked vehicle driven by Detective Alex Rodriguez. As the officers approached the intersection of St. Charles and Belvedere, Detective Ramsey observed a large group of individuals congregating. When appellant saw the unmarked vehicle, he turned and began walking away from the group. The appellant had a satchel positioned across the front portion of his body. While appellant was walking, Detective Ramsey saw the rear handle of a handgun, in the front side the front right side of appellant's waistband. The handgun was physically printing through the shirt, meaning that Detective Ramsey could see the angular shape, the back portion of an LL line of the rear handle of the handgun through appellant's shirt. Now, is that enough to warrant a search? Probably not, because there's lots of objects that can make that same shape. Detective Ramsey activated his body-worn camera, exited his vehicle, and told appellant to put his hands up. Appellant asked for what, then immediately stated that he had a license. Detective Ramsey told appellant that he was stopping him because he observed a firearm physically printing in appellant's waistband, and he placed appellant in handcuffs. Appellant reiterated that he had a permit for the gun and asked if he could pull out his license. Detective Ramsey explained that he had an investigation to conduct. In what? The handgun was located in a holster inside of appellant's waistband. Detective Ramsey alerted surrounding officers that there was a gun in appellant's waistband. Another officer, Detective Rodriguez, removed the gun and handed it to Detective Ramsey, who rendered it safe by ejecting the magazine and wrecking the slide of the weapon. Okay. So far, we have an officer who is ignoring the fact that the person carrying said firearm had a license to carry said firearm. That should have ended the investigation right there, because the only thing that the officer had observed the guy doing illegally was potentially carrying a firearm without a license. As soon as it was identified that the guy had a license and he wanted to show the officer should have stopped right there. That's it. Boom, done.
Well, he's going to say officer safety.
Except for once the guy says he has the license, there's no crime that the officer has observed for him to be investigating for officer safety.
Since when has not having a crime ever stopped a cop?
Yeah. That's what I'm saying, though, that the officer was wrong to continue this.
Oh, I wholly agree. I'm just saying.
Yeah.
That's going to be the excuse, was officer safety.
Which is the excuse that was used, going back to the summary. At the suppression hearing, Detective Ramsey testified that he then stepped away from the appellant while other officers conducted a continued weapons pat-down of appellant's person. During the pat-down, officers recovered a second firearm from the satchel and CDS from appellant's left pants pocket. Detective Ramsey observed the CDS recovered and described them as small trash cans, multicolored trash cans commonly utilized to package and hold street-level cocaine within Baltimore City. After discovering the CDS, Detective Ramsey gave appellant his Miranda warnings. He asked him where his license was located, and the appellant replied, "Bro, it's right here in my things. I was going to get it." Detective Rodriguez did not testify at the suppression hearing. Instead, the state introduced Detective Rodriguez's body camera footage into evidence and played it for the court. The video shows Detective Rodriguez approaching suspect as Detective Ramsey detained him and another officer handcuffed him. Appellant asked why they stopped him and repeatedly stated that he was licensed. Detective Ramsey explained that he stopped appellant because he saw a firearm in his waistband, and even though appellant said that he had a license, the police still had to do an investigation. No, once he told you had a license and he presented it, that's it. Or tried to present it, but you wouldn't let him. The video shows Detective Rodriguez removing the firearm, which was located in a holster from the right side of appellant's waistband. Detective Rodriguez put his hand slightly into the satchel, pulled away the unzipped back pocket, felt the inside of the satchel, and stated that there's a second firearm inside the bag. Detective Rodriguez removed the satchel and handed it to Officer David Birch, instructing him to zip it up, zip it up. Officer Birch opened the main compartment of the satchel and looked through it, then handed it to another officer. Detective Rodriguez introduced himself, explained that appellant was being recorded, and reiterated that the officers stopped the appellant because they observed his firearm printed from his waistband, which again was not in and of itself a crime. While holding on to appellant's waist and briefly patting down appellant's outside right pocket, Detective Rodriguez asked appellant if there was anything on him that he should know about. Appellant's response was unintelligible. Detective Rodriguez briefly felt the outside of appellant's left pocket and then started to pull out a plastic baggie from inside appellant's pocket. He stated that he needed gloves and then pulled open the pocket to look at the contents inside. Detective Ramsey then read appellant his Miranda rights. Approximately 5 minutes later, Detective Rodriguez put on gloves and removed from appellant's pockets the plastic baggie, as well as numerous small plastic containers. He then searched appellant's entire satchel. The video shows Officer Birch transferring small plastic containers from the satchel into an evidence bag. On cross-examination, Detective Ramsey testified that the officers were in the neighborhood for an investigation unrelated to appellant. They observed appellant laid his body and crossed directly behind their unmarked vehicle. Appellant did not take off running when Detective Ramsey told him to stop and put his hands up. Appellant did not put his hands up, however, and one hand was close proximity to where Detective Ramsey observed a firearm. Detective Ramsey was aware that people have concealed carry permits in Maryland. The gun was under appellant's shirt in a holster and not in view. Another gun was discovered in appellant's satchel by a different officer. When stopped, appellant immediately told Detective Ramsey that he had a license. Detective Ramsey put appellant's hands behind his back. Appellant reiterated that he had a license 3 times as he was handcuffed and surrounded by 4 officers. As the body cam video played, Detective Ramsey identified the officers present at the scene. He testified that Detective Rodriguez reached into appellant's satchel with his right hand. Appellant again asked if he could get his license, but none of the officers responded to his request. I'm not reading all the footnotes. Detective Ramsey testified that Detective Rodriguez conducted an initial pat-down of appellant prior to reaching in his pockets and discovering a bag of cocaine. Defense counsel introduced for identification of appellant's firearm permit, which indicated an expiration date of February 28, 2026, with no restrictions. Keep in mind this case happened in 2023. It just now got to where it has a appeal decision with no restrictions on the license, in other words. The state stipulated that it was the permit discovered that day. In argument, the state relied on State v. Sizer 230 Maryland, appellate 640, 651, 2016. Affidavit on other grounds. Yeah, I'm not going to go through all those. You can read it there if you want. To support its position that there was a reasonable, articulable suspicion of an armed person. When appellant was detained, and there was a reason for the pat-down leading to the recovery of the first gun. So yeah, reasonable, articulable suspicion of an armed person. Well, yeah, you knew it, and he told you that he had the permit. It argued that the pat-down led to recovery of the second gun in the satchel, and continued pat-down after removal of the satchel led to the discovery of CDS. The state asserted that the officers acted reasonably under the totality of the circumstances in handcuffing appellant before conducting a Terry frisk, because appellant's hand was inches from his gun, and the officers needed to get control of the situation before verifying the permit. Appellant's counsel began by stating that appellant was in full compliance with Maryland's permitting statute when the officers detained him, and the initial question was whether the circumstances were enough to justify the stop. He argued that if the court ruled it was enough to justify a frisk after the decision in New York State Rifle and Pistol Association, Inc. versus Bruin, an officer must show that a person is armed and dangerous, and armed does not automatically mean dangerous. Counsel argued that appellant was not dangerous because when the appellant was ordered to stop, he immediately did so, faced the officers, did not reach for anything, and stated several times that he had a license. He argued that it was incumbent on the officers to verify the license at that point, but instead, Detective Rodriguez removed the appellant's weapon and started digging in the satchel. Counsel asserted that under McDowell v. State, Detective Rodriguez was not authorized to pull out the bag of cocaine in the appellant's pockets because he knew it was not a weapon. He argued that the search was not reasonable and at very least the cocaine should be suppressed. He also noted that Detective Rodriguez was not called by the state to testify regarding the discovery of the cocaine based on the plain field doctrine. In reply, the state noted that only 1 minute and 40 seconds passed between the time Detective Rodriguez exited from the vehicle and the time he felt the drugs in the appellant's pocket. During that 100 seconds, the officers had not had the opportunity or the time to verify a permit because they needed to get control of the situation. Really? Stop. Guy stops. Guy turns around. Guy faces officer, does not grab his weapon, says, I have a permit. Guy asks permission to grab his permit. Officers tell him no. That's all within that time frame. So officers had plenty of time to authenticate whether the guy had a permit or not. The state did not agree that Detective Rodriguez reached into the bag, and in any event, it argued that there would have been inevitable discovery once appellant was placed under arrest for the drugs. It asserted that the officers acted reasonably. The state compared stopping an individual with a suspected concealed weapon to stopping individuals driving cars with a barely legal window tint, noting that even if they are actually in compliance, there's still a reasonableness to investigate. The court denied appellant's motion to suppress, finding that the officers acted reasonably to protect themselves and protect the public. It stated that you can have 453,000 handgun permits valid, legal, if you walk around the streets of the United States, not just Maryland. Well, I can't say United States because you can do it probably in Texas, but if you walk around the streets of Maryland, Baltimore City with a handgun, a weapon which has clearly obvious to me when I first saw you that that's what was under that t-shirt, you're going to get stopped. That is just the nature of the beast. You can have all the permits you want, sir. When a police officer sees that you have a gun, you could have been a police officer. It would not matter if they did not know you. They would have been well within their means to stop you. No, they wouldn't. Noting that a person could lie about having a permit, or even if the person had a permit, use the gun to shoot the police or members of the public, the court found that the officers were well within their right to stop appellant for their safety as well as the safety of the community at large. With regard to the second handgun recovered, the court found that the back zipper of the satchel was open when Detective Rodriguez removed the first gun from the appellant's waistband. The court stated he stuck his hand in there. I don't know what he might find. I don't know, maybe ammunition, who knows? But something he saw in there, he put his hand in, and then he immediately took his hand out, waited, and said, we got a firearm inside the bag. The court reiterated that the officers would be neglecting their duties, their own safety, and the safety of the community if they believed everyone who claimed they had a license without verification, and explained that no reasonable police officer is going to allow you to go in your pocket or try to find your license, or go in that bag and try to find your license where there could be another weapon. If it doesn't work like that, sir, that's not how officers are trained, and that's not what they should do. I can dispute that one. The court found that the search of an appellant's pants pocket was reasonable as a frisk to protect the police and the community. As indicated, after the court denied the motion to suppress, appellant entered a conditional guilty plea to possession of a firearm with a nexus to a drug trafficking crime. The court sentenced him to 5 years of incarceration without possibility of parole. This appeal followed. The parties briefed the issues they were presenting to the court, and argument ensued before a 3-judge panel. Okay, so yes, this did go to a 3-judge panel. The majority of this court subsequently voted to hear the case en banc, and the court held an en banc hearing on March 31st, 2026. Okay. So yes, it did go to a 3-judge panel and then to an en banc decision. So there's your answer to your question, Foss. Standard of review. The standard of review for a motion to suppress is well established. When reviewing a circuit court's denial of a motion to suppress evidence, we are limited to the record developed at the suppression hearing. Motes v. State. We review the evidence and the inferences drawn therefrom in the light most favorable to the prevailing party. That's Thornton v. State. As a mixed question of law and fact, we accept the hearing court's findings of fact unless they are clearly erroneous, but review the hearing judge's legal conclusions de novo. Thus, we independently evaluate without deference to the circuit court whether a police officer's conduct violated the constitutional right of the defendant. State v. Smith, a bunch of court cases. Discussion. Appellant contends that court erred in denying his motion to suppress. He makes several arguments in support of this contention. First, he argues that the stop was unconstitutional in light of Bruin, asserting that A, the encounter was an arrest unsupported by probable cause because post-Bruin knowledge that someone is carrying a gun cannot generate probable cause is that they are doing so illegally. And B, even if the encounter constituted a Terry stop, in light of Bruin, the police did not have reasonable suspicion to detain him. Second, appellant argues that even if the stop was lawful, the frisk was not justified because police lacked reasonable suspicion that he was dangerous. Finally, appellant argues that even if the stop and frisk were warranted, Detective Rodriguez exceeded the permissible scope of a Terry frisk for weapons by immediately putting his hands into appellant's bag and pockets. He asserts that the state failed to present evidence to justify this search under the plain sight and plain field doctrines because Detective Rodriguez did not testify. The state contends that the court correctly denied appellant's motion to suppress. It argues that the appellant's encounter amounted only to an investigatory detention, not an arrest, and the stop was supported by reasonable suspicion that the appellant carried a handgun unlawfully. The state asserts that Bruin does not alter the foundational premise that by statute in Maryland, the carrying of a handgun is presumptively unlawful, with certain exceptions, including possessing a permit, and therefore an officer may detain an individual with a handgun to determine if the individual possesses a valid permit. With respect to the frisk, the state argues that a reasonable suspicion that a person is armed is per se a reasonable suspicion that a person is dangerous, warranting a frisk for weapons. Regarding the scope of the frisk, the state contends that appellant did not preserve for review his claim that the frisk exceeded its proper scope, and in any event, Detective Rodriguez lawfully seizing the handgun and cocaine under plain sight and plain field doctrines. The Fourth Amendment to the United States Constitution guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. U.S. Constitution Amendment 4. The ultimate touchstone of the Fourth Amendment is reasonableness. Richardson v. State, quoting Riley v. California, whether a particular warrantless action on the part of the police is reasonable under the Fourth Amendment depends on a balance between the public interest and the individual's right to personal security, free from arbitrary interference by law officers. As indicated, appellant presents several arguments in support of its contention that the encounter here was not reasonable under the Fourth Amendment. Because appellant relies heavily on the decision in Bruin to support these arguments, we will briefly discuss that case and Maryland's response to it to date before addressing appellant's specific contentions. Legal background. In Bruin, the United States Supreme Court issued a ruling that substantially changed the legal landscape. It held that the Second and 14th Amendments to the United States Constitution protected an individual's right to carry a handgun for self-defense outside the home. The case arose from a challenge to the constitutionality of New York's licensing regime, which made it a crime to possess any firearm without a license and provided that to obtain a license to carry a concealed gun, the applicant must show proper cause. The proper cause requirement had been interpreted to require an applicant to demonstrate a special need for self-protection distinguishable from that of the community. The court stated that if the Second Amendment plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The court held that the plain text of the Second Amendment, which provides that the right of the people to keep and bear arms shall not be infringed, protects an individual's right to carry handguns publicly for self-defense. Based on that plain language, the government had the burden to justify any regulation on handguns by showing that it was consistent with the nation's historical tradition of firearms regulation. The court acknowledged that the right to keep and bear arms in public has traditionally been subject to well-defined restrictions governing the intent of which one would carry arms, the manner of carry, or the exceptional circumstances under which one could not carry arms. It concluded, however, that the historical record compiled by respondents does not demonstrate a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense or limiting public carry only to those law-abiding citizens who demonstrate a special need for self-defense. Give me a second. Had to get a drink. My mouth was getting dry. Accordingly, the court held that New York's proper cause licensing requirement was unconstitutional. Prior to Bruin, states with permitting schemes were either shall issue or may issue regimes. Folks v. State Okay. According Bruin shall issue regimes. 43 states in 2022 required authorities to issue concealed carry licenses if applicants satisfy certain threshold requirements. They did not require applicants to show an atypical need for armed self-defense and did not necessarily prevent law-abiding responsible citizens from obtaining a permit for public safety. Rather, they imposed narrow, objective, and definite standards, such as background checks and firearm safety courses, to confirm the licensees were, in fact, law-abiding. May issue regimes, by contrast, which includes 6 states in 2022, including Maryland and New York, required a special showing of need to obtain a permit to carry a firearm in public and gave authorities discretion to deny concealed carry licenses even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability for the relevant license. Prior to Bruin, Maryland's May issue licensing regime required applicants for a permit to carry a handgun to show that they had good and substantial reason to wear, carry, or transport a handgun, such as a finding that a permit was necessary as a reasonable precaution against apprehended danger. In rounds, again, we get the long number for the case. Maryland courts had interpreted this requirement to mean that an applicant must demonstrate having received actual threats or assaults to qualify for a permit. After Bruin, this court held that the good and substantial reason requirement of yada, yada, yada was unconstitutional. In 2023, the General Assembly amended PSS 5306 to remove the good and substantial reason requirement effective October 1st, 2023. Maryland is now a shall issue state, and its citizens are authorized to obtain a concealed carry permit provided they are 21 years of age or a member of the uniformed services, do not have any disqualifying offense or mental disorders, do not have a substance abuse disorder, have successfully completed a firearms training course, and, based on an investigation, have not exhibited a propensity for violence or instability that may reasonably render the person in possession of a handgun a danger to the person or to another. Applicants must also show that they are not otherwise prohibited by state or federal law from purchasing or possessing a handgun. Yeah, keep in mind, Maryland still has the you got to get a permit to get a permit in place. With this background in mind, we now turn to the issues presented on appeal. Initial encounter. Appellant first challenges the initial encounter. There are 3 categories of police-citizen encounters: an arrest, an investigatory stop, and a consensual encounter. An officer is free to ask questions to persons on the street in a consensual encounter without any suspicion of criminal activity, but in that situation, the person has a right to ignore the police and go about his business. That comes from Illinois v. Wardlow, and it's a decision from the U.S. Supreme Court. And it also coincides with Terry, which is also a case from the Supreme Court of the United States. Here, the encounter between the appellee and the police was not consensual. There is no dispute that the appellant was seized when the police stopped him and placed him in handcuffs. See Florida v. Bostic, again, United States Supreme Court. Seizure of a person under the Fourth Amendment occurs when police communicates. That's weird. To a reasonable person that the person was not free to decline the officer's request or otherwise terminate the encounter. In Terry, a seizure occurs when a police officer accosts the individual and restrains that person's freedom to walk away. Yeah, normal state. Seizure is any non-consensual detention. The individual dispute here involves type of seizure involved and whether it was justified by the requisite levels of suspicion. There are 2 types of seizures that implicate the Fourth Amendment. 1, an arrest, which must be supported by probable cause, and 2, an investigatory stop or a Terry stop, named after the Supreme Court's decision in Terry v. Ohio. which must be supported by reasonable suspicion. Long list of cases. We need not determine here whether the individual encounter constituted an arrest requiring probable cause. As we shall explain below, we agree with the appellant that even if the initial encounter was an investigatory stop, a lesser intrusion, it was unconstitutional because police did not have reasonable suspicion to stop appellant. Reasonable suspicion standard. Pursuant to Terry, a law enforcement officer may stop an individual if the officer has reasonable suspicion that a person is involved in criminal activity. According to Wardlow, an officer may, consistent with the Fourth Amendment, conduct a brief investigatory stop when the officer has a reasonable, articulable suspicion that a criminal activity is afoot. Generally, an officer has reasonable suspicion to conduct a stop when there is a particularized and objective basis for suspecting that the particular person stopped of criminal activity. The Supreme Court of Maryland has explained the standard as follows. Reasonable suspicion is a common sense, non-technical conception that considers factual and practical aspects of daily life and how reasonable and prudent people act. Though a level of required suspicion is less than that required by the probable cause standard, reasonable suspicion nevertheless embraces something more than an inchoate and unparticularized suspicion or hunch. In other words, they can't just think somebody's doing something. They have to be able to reasonably substantiate that somebody was doing something. The reasonable suspicion standard does not deal with hard certainties, but with probabilities. There are circumstances where wholly lawful conduct may justify the suspicion that criminal activity was afoot. According to U.S. v. Rodriguez, an officer may not, however, merely assert that innocent conduct was suspicious. See State v. Stone. Rather, he or she must explain how the observed conduct, when viewed in the context of all other circumstances known to the officer, was indicative of criminal activity. Officer must have reasonable suspicion that a particular person is committing, or is about to commit a crime to conduct an investigatory stop. An investigatory stop may last only as long as necessary to confirm or dispel an officer's suspicion. It's, in other words, in this case, as soon as the guy stated that he had a permit and was willing to show it, the stop had to end because at that point the officer's suspicion was dispelled. Evidence to suspect criminal activity. Before addressing reasonable suspicion in the context of gun possession, we address 3 cases issued by the Supreme Court of Maryland that analyze whether the police had reasonable suspicion to stop a person based on conduct or circumstances that could be criminal in some circumstances, but not criminal in other circumstances. The first case is State v. Williams, where the Supreme Court of Maryland considered whether the police properly stopped the vehicle based on suspicion that the tinting of the vehicle's rear window was in violation of the statutory requirement that post-manufacturer window tinting permit light transmittance of at least 35%. The officer testified that he stopped the vehicle because the window was darker than normal. The court held that this evidence was insufficient to give the officer reasonable suspicion to stop the vehicle because the law permitting tinting that blocked 65% of light, and the officer did not have reasonable suspicion that the window was not in compliance with the statutory requirement. The court rejected the state's argument that any tinted window could justify a stop, stating that this would effectively strip away Fourth Amendment protection for any person driving or owning a car with tinted windows. To justify a stop for a tinting violation based on an officer's observation, the officer must credibly articulate why the officer believed that tinting was illegal. In the second case, the court addressed whether the odor of marijuana by itself provided reasonable suspicion justifying an investigation detention. Although prior cases had held that it did, in DD, the court was required to address, similar to this case, the impact of a charge in the law on the reasonable suspicion analysis. Prior to 2014, marijuana possession in any amount was illegal. In 2014, the General Assembly decriminalized possession of less than 10 grams of marijuana. Possession of less than 10 grams of marijuana remained a civil offense, however, punishable by fines and other remedies, and therefore it was still illegal. In addressing the issue, the court began by noting that it held in Lewis v. State that the odor of marijuana on a person by itself did not provide probable cause to believe that the person was in possession of a criminal amount of the drug to authorize an arrest of the person. In declining to extend its holding in Lewis to Terry stops, the court noted that the encounter with Dede was different, and the limited nature of the brief investigative stop does not demand a standard as stringent as probable cause. Although the odor of marijuana does not reveal the quantity of marijuana potentially held by a person, and therefore it did not give the police probable cause to arrest. The odor was not irrelevant because it provided evidence of a crime. The court recognized that there could be innocent reasons that a person smelled of marijuana, but it noted that the innocent conduct can amount to reasonable suspicion. It held that although the quantity of evidence that the quantum of evidence rather, that the odor of marijuana provides is insufficient to justify an arrest based on the probable cause standard, it meets the reasonable suspicion standard necessary to justify a brief investigatory detention. In reaching its decision that the odor of marijuana gave police probable suspicion to stop a person, the court stated that it declared or declined to significantly hamper the legitimate investigation of criminal activity in Maryland. It stated that law enforcement officers do not need to rule out innocent explanations for suspicious conduct before conducting a Terry stop. And given the important governmental interest in detecting, preventing, and prosecuting crime, the Fourth Amendment allows a brief seizure based on reasonable suspicion to determine whether criminal activity is afoot. The court acknowledged that in some instances, an individual may be stopped based on non-criminal behavior, stating when a police officer smells marijuana, okay, we're going to keep on going with the marijuana thing. In the third case, Stone at Supreme Court of Maryland, a 4-3 decision held that its holding in DD and discussion of the reasonable suspicion standard was tied to a unique situation posed by the odor of marijuana. In Stone, the court addressed whether the officer's observation of a defendant manipulating a mobile phone while his vehicle was in motion constituted reasonable suspicion for an investigatory stop. In holding that it did not, the court noted that it is illegal while operating a motor vehicle to use a device for certain purposes, such as texting, but it is permissible to use a device for other purposes, such as contacting a 911 system. The court held that although the defendant may have been engaged in conduct that was indicative of either lawful or unlawful activity, the officers did not identify any facts to support the determination that there was an objectively reasonable basis to suspect that he had committed or was committing a traffic violation. It stated that where conduct observed by a police officer is consistent with lawful or unlawful activity, the police are justified in conducting an investigatory stop only if they are able to credibly identify specific facts not applicable to a substantial portion of general law-abiding public, which, taken together with rational inference from these facts, reasonably establish that a crime is occurring. Ugh. This is a mouthful. In distinguishing DD, the court stated that DD did not stand for the proposition that any time officers observe that a person is engaged in behavior that appears to be either completely innocent or innocuous, conduct that could be indicative of lawful or unlawful behavior, officers have reasonable suspicion to stop the person, resolve any ambiguity as the type of conduct the person is engaged in. As indicated, the court stated that its holding in DD addressed the unique situation posed by a marijuana odor, which remained indicative of criminal behavior, but the premise of an investigatory stop being generally permissible to clarify any ambiguity with respect to a police officer's observations as to whether a person is or is not engaged in unlawful activity was not discussed or even mentioned in DD. With that background in mind, we address reasonable suspicion in the context of possession of a gun. Reasonable suspicion based on gun possession. To determine whether a police officer had reasonable suspicion to believe that a person was involved in criminal activity, we must look at the law alleged to be implicated. Section 4, 203A1 of the Criminal Law article states, Except as provided in subsection B of this section, a person may not, at 1, or I, wear, carry, or transport a handgun, whether concealed or open or not about his person, wear, carry, or knowingly transport a handgun, whether concealed or open in a vehicle traveling on a road or parking lot generally used by the public highway, waterway, or airway of the state, violate item I or double I while on public school property or in the state, violate item I or double I with the deliberate purpose of injuring or killing another person, or okay, it's 1, 2, 3. It's a weird way to Roman numeral it when Roman numerals haven't been used yet. 5, violate item 1 or 2 with handgun loaded with ammunition. There are, however, numerous circumstances where handgun possession is not illegal, and these circumstances are set forth in CR 423B. The relevant circumstances here is the wearing, carrying, or transporting of a handgun by a person or to whom a permit has been issued. Here, the police stopped the appellant when Detective Ramsey saw a gun printing on appellant's shirt. A police stop based on reasonable suspicion that a person is in possession of a gun has consistently been upheld by Maryland appellate courts as a proper Terry stop. See State v. Smith. Permissible when officers are the defendant placed an object believed to be a handgun in the back waistband or of his pants. Quince v. State, stop and frisk was constitutionally permissible because officer had reasonable and articulable suspicion that defendant was unlawfully carrying a handgun based on a reliable tip. Allen v. State, investigatory stop permissible where officer had reasonable articulable suspicion that the defendant was armed based on a tip and that the area was a known high crime area. See also Russell v. State, officer had reasonable suspicion to continue detention after traffic stop based on concealment of suspected handgun in defendant's pocket. At the time these decisions were issued, Maryland had a May-issued licensing scheme in rounds. To prove the crime of wear, carry, or transport a handgun, the state merely had to prove possession of a gun, and the defendant had the option to raise as an affirmative defense to the wearing, carrying, or transporting of a handgun prohibition that the defendant had a permit. See Brogdon v. State. Prior to Bruin, other courts held that when it was presumptively unlawful under state law to carry a firearm, with exceptions including when an individual had a permit, a police officer with reasonable suspicion to believe that a person had a gun could conduct a Terry stop to determine the legality of gun possession. For example, in United States v. Rodriguez, the court held that an officer had reasonable suspicion to stop and frisk the defendant based on the officer's observation of a handgun tucked in the defendant's waistband at a convenience store. The court held that because New Mexico's statute provided that carrying a concealed weapon was presumptively unlawful, subject to exceptions including possession of a handgun license, the officer could detain the defendant based on reasonable suspicion of criminal activity. It concluded that the exceptions in the law did not negate the officer's reasonable suspicion that the defendant's possession of a concealed handgun was unlawful. Similarly, in U.S. v. Gatlin, the court held that under Delaware law, carrying a concealed handgun is a crime to which possessing a valid license is an affirmative defense, and an officer can presume a subject's possession is not lawful until proven otherwise. The court stated that it is presumed in Delaware that concealed handgun bearers are violating the law, and that suspect might later offer a license as an affirmative defense does not affect the reasonable suspicion analysis under Terry. According to U.S. v. Pope, reasonable suspicion to stop and frisk the defendant with handgun and waistband because under Iowa law it is presumptively criminal to carry a concealed weapon until that suspect comes forward with a permit. United States v. Lewis concealed handgun established reasonable suspicion where a permit was affirmative defense to crime, yada yada. Appellant contends, however, that this analysis changed after Bruin, where the United States Supreme Court held that gun possession is not only lawful, but it is a protected constitutional right. Appellant argues that post-Bruin gun possession can no longer on its own, as in this case, constitute reasonable suspicion that a crime is afoot. He asserts that what constitutes reasonable articulable suspicion of criminal activity must necessarily change as the law changes what conduct is illegal. Appellant argues that the police here did not have reasonable suspicion to stop him when he was merely walking up the street in broad daylight with a concealed firearm, which is broadly permissible under Maryland's shall issue licensing regime. The state contends that the officers had reasonable suspicion to conduct an investigatory stop of appellant. It argues that the analysis of whether reasonable suspicion to believe a person is in possession of a gun justifies an investigatory stop depends on each state's substantive criminal law, not Bruin. The state argued in its brief that Bruin did not alter the Fourth Amendment analysis in Maryland because in this state, unlike other states, carrying a handgun is presumptively unlawful and becomes lawful only under certain exceptions, including possession of a permit. The state asserts that presumptions governing the legality of handgun possession turn on each state's substantive criminal law, not Bruin. It contends that under the legal standard for reasonable suspicion, an officer need not know that a suspect carrying a handgun doesn't possess a valid permit to investigate that very fact. As appellant notes, post-Bruin, jurisprudence on the intersection of the Second and Fourth Amendment protections is in its infancy. Nevertheless, reported opinions that have addressed the issue presented here post-Bruin and have analyzed Bruin in a holdings regarding the existence of reasonable suspicion have concluded, as appellant argues, that possession of a gun without more does not provide reasonable suspicion authorizing a stop. For example, in the United States v. Wilson, the court addressed a Terry stop in the context of Louisiana's law, which, similar to Maryland, prohibited possession of a concealed firearm, but the prohibition did not apply to a person with a valid permit. The court rejected the district court's determination that this statute made possession of a firearm presumptively unlawful, justifying a Terry stop for anyone carrying a firearm. It reasoned that a per se presumption of illegality was inconsistent with the Constitution's history and tradition, inconsistent with the Terry doctrine, which requires individualized suspicion and does not include a firearm exception, and inconsistent with the Fourth Amendment generally, which does not allow for suspicionless searches to combat general crime. It noted that a mere possibility of an unlawful use of a gun is not sufficient to establish reasonable suspicion. The court said that a per se presumption of illegality would have untenable consequences in other areas. It compared gun licenses to driver's licenses, noting that driving a car without a license is unlawful in every state, yet the United States Supreme Court had held that stopping a vehicle to verify compliance with license and registration requirements without articulable and reasonable suspicion that a motorist is unlicensed or that an automobile is not registered violated the Fourth Amendment. The court stated that officers cannot assume that citizens engaged in an activity subject to licensing are unlicensed. Citing Bruin, the court stated that the Constitution's prohibition on presuming illegality should be stronger for gun owners than for car drivers because the right to carry a handgun is protected by the Second and 14th Amendment. Regardless of how a state's permitting scheme was set up, possession of a gun was presumptively lawful nationwide, and police could not rely on a presumption that carrying a firearm was unlawful to justify a Terry stop. Similarly, in People v. Dorsey, the Appellate Court of Illinois held that the mere possibility that anyone with a gun might not have a valid license is not enough to justify a Terry stop. The court concluded that in a jurisdiction such as Illinois, where carrying a firearm in public is permitted with a license, an individual's possession of a gun alone is nothing more than an exercise of a protected constitutional right and cannot automatically subject a citizen to police detention. It noted that officers could, in a consensual encounter, verify that the status of a citizen's licensure. Alternatively, they could conduct an investigatory stop if there were specific and articulable reasons to believe the citizen did not have a valid license or was otherwise implicated in an imminent criminal activity. The mere possibility that anyone with a gun might not have a valid license, however, was not enough to justify a seizure. For that, the police had to have specific and articulable reasons to believe that this person, observed in these circumstances, did not have a valid license or that he was otherwise implicated in imminent criminal activity. That would be United States v. Jones. Mere possession of a handgun without further evidence of criminality is not enough to show reasonable suspicion. In United States v. Daniels, the 10th Circuit held that officers did not have reasonable suspicion to stop the defendant based solely on an anonymous tip that three men had guns and looked like they were getting ready to do something. Noting that the tip did not allege any criminal activity or dangerous behavior, the court stated that if we are to take seriously the normative thrust of Bruin, then we cannot look with suspicion on citizens presumptively exercising their Second Amendment rights in a lawful way. Based on the Based on the totality of the circumstances, the court held the officer's detention of the defendant was unreasonable under the Fourth Amendment. To be sure, there have been a few courts that have stated in reported opinions at the Bruin that the police have the authority to stop a person to investigate whether an individual with a handgun has a lawful permit. Those statements, however, in this case cited to us, have been made either in dicta without analysis or without citation to Bruin. For example, in United States v. Libertad, United States v. Marine, the court noted that courts had long affirmed the reasonable suspicion that a person is carrying a gun to support a brief Terry stop. The court initially acknowledged that post-Bruin, it was hard to say that suspicion or even knowledge that someone is carrying a gun constitutes suspicion or knowledge of criminal activity. It then stated that this specific question was not before the court because the stop there occurred prior to Bruin, when New York still had a highly restrictive licensing scheme limiting a person's ability to obtain a license to carry a firearm outside the home. The court held that because the stop was prior to Bruin, there was reasonable suspicion of unlawful activity. Nevertheless, the court went on to state in dicta that if it doubted that even after Bruin, the police could not stop someone carrying a gun and verify that the person was doing so lawfully. The United States v. Homer, the court held that there was no probable cause to arrest the defendant, who officers observed sitting in a vehicle known to be used for gang activity and placing a handgun in his pants pocket while firearm discipline. The court noted that under the stricken proper cause licensing regime prior to Bruin, where it was difficult to obtain a firearms license, it was reasonable for the police to believe that a person in possession of a gun was committing a crime. After Bruin, however, the New York legislature amended the firearm licensing regime to make gun licenses for firearms significantly more accessible. At this point, the licensing exception that police could have reasonably disregarded before Bruin was substantially broadened so that police can no longer reasonably assess whether a person was committing a crime without taking the exception into account. The court held that to establish probable cause after Bruin, the police must point to facts in the lead up to the arrest that indicate that to the arresting officer, based on his experience and expertise, that the defendant did not have a license to carry a firearm. Good luck with that. The court went on to note, however, in dicta that the officers had other options after Bruin. It stated without analysis that even after Bruin, police officers have reasonable suspicion to justify Terry stop when seeing someone they suspect has a gun. The court stated that the officer could have stopped Homer and conducted a Terry frisk to remove the gun when they determined after running a license check whether there was probable cause to arrest the defendant. It stated that a Terry stop provides the police the tools to ensure that they protect the right of the public to be free from unreasonable searches and seizures while preventing the unlawful possession and carrying of firearms. We have carefully reviewed the cases in other jurisdictions, the holding in Bruin that the Constitution presumptively protects gun possession, and the decisions by the Maryland Supreme Court in Stone and Williams. Based on this review, we hold that post-Bruin reasonable suspicion to believe that a person is carrying a gun by itself no longer justifies a Terry stop. Our colleagues filing concurrences have discussed the danger posed by guns. A motion for, I'm not reading that. Freeman Shaw, Yeah, it's all the concurring that I read earlier. We agree that guns can be dangerous, a concern echoed by the United States Supreme Court when Terry was decided in 1968. Since the time of Terry, however, there have been major changes in the law with respect to possession of firearms. In 1968, when Terry was decided, the law of Ohio, the state at issue in Terry, made it a crime to possess a concealed firearm, with the exception only for law enforcement. Thus, it was probable that a person on the street who was not in law enforcement was committing a crime if they possessed a gun in public. Similarly, in Maryland at the time, the possession of a dangerous weapon, concealed or openly with the intent to injure, was a crime, with the exception for officers of the government and persons carrying weapons as a reasonable precaution against apprehended danger. States subsequently created more exceptions to the crime of possession of a gun, including for those who obtained licenses. Maryland added that exception in 1969. Based on this statutory scheme, possession of a handgun was presumptively illegal, and having a permit was affirmative defense. Accordingly, the Maryland Appellate Courts consistently held that reasonable suspicion that a person was in possession of a concealed weapon justified an investigatory stop. In Bruin, however, the United States Supreme Court changed the legal landscape. After Bruin, carrying a handgun publicly for self-defense is presumptively lawful, where Second Amendment's plain text covers an individual's conduct, such as carrying a handgun publicly for self-defense. The Constitution presumptively protects that conduct. After Bruin, possession of a gun is presumptively lawful nationwide, indicating that a statute presumes criminality, Constitution protected under unconstitutional. I'm trying to get to the word. Yeah, just a bunch of quoting. Without presumption of illegality, mere possession of a handgun is not by itself indicative of criminal activity that justifies an investigatory stop. To be sure, this holding is a big change in the law. Arguably, it is not a positive change to the extent that it limits the ability of the police to thwart danger to the public. And that's a matter of opinion. Nevertheless, our holding that mere possession of a handgun by itself does not provide reasonable suspicion to support a Terry stop is, in our view, compelled by Bruin. And it is consistent with the Supreme Court of Maryland's holding in stone that where conduct observed by a police officer is consistent with lawful or unlawful activity, the police are justified in conducting an investigatory stop only if they are able to credibly identify specific facts not applicable to a substantial portion of the general law-abiding public, which, taken together with rational inferences from these facts, reasonably establish that a crime is occurring. Yeah, this is going back to all the previous cases and stuff we already read. Our holding does not, however, leave the police powerless. As indicated, the police are permitted to engage in a consensual encounter with an individual. They can approach someone and ask if they have a license, which isn't what happened here. Moreover, if there are circumstances in addition to the possession of a firearm that give the police reason to suspect the person is possessing the gun illegally or otherwise is involved with criminal activity, the police lawfully can stop the person. Yeah. The mere possibility, however, that a person with a gun might not have a valid license or it may otherwise be restricted from possessing a gun is not enough by itself to justify a seizure. To justify a stop based on possession of a gun, the police must have reasonable suspicion that the person is possessing the gun illegally. In this case, the police did not testify that they believed the appellant was possessing the gun illegally, and no argument was made to the suppression court to that effect. The case was presented below as a stop justified solely on possession of a gun, and it was presented in the briefs on appeal the same way. That is the argument that we have addressed, and it is the basis for a conclusion that the stop was unconstitutional. And then it goes into the concurring opinions. I'm not reading all this. You get the basic idea. The court ruled that they acted illegally, unconstitutionally. So, any opinions from you guys at this point?
If you do show prep, you can pre-read this stuff, pull clips out of it,
here's the thing. I just found out about this case like an hour, like a couple hours before I was doing this, and I didn't have time to do any of that. I mean, this is essentially just about breaking news right now.
Yeah. So I should have taken notes because I don't know, I kind of zoned out a bit. The tinted windows is what's being used now to pull people over.
Mm-hmm.
Based on training and experience, I could tell the tint was too dark.
Mm-hmm.
That's how they pull you over to get a good look at what you're doing. Um,
Back in the 80s in Pennsylvania when the window tinting really was starting to take off. And they had numerous stops that were overturned on appeal because the judge was like, unless you've got some kind of gauge, there's absolutely no way that you can make that.
well, now they have gauges that they'll set on the. Well, I see what I see what you're saying that to do the stop in the first place, but they have little gauges that they'll set on the window. They'll have them roll down the window and it'll clip over the top of the window to read the darkness.
Barbecue says, you could have done with it. No, Barbecue, I couldn't. I didn't have time to because I had other things I had to do today. So, no, I did not actually have the physical time to go and pre-read this.
It was good. It's not going to completely stop it from happening because there's still stuff that the Supreme Court has ruled multiple times on that cops will, like swearing in public. It, you know, it seems to be kind of southern is where you see more of the videos of it, but they'll hit people with disorderly conduct. Well, the Supreme Court ruled that you don't have a right to not be offended. Basically, as long as it's not fighting words.
Mm-hmm. Yeah, exactly.
It's legal.
The fighting words doctrine is the one thing, and that's basically you keep hounding somebody to the point where anybody who's reasonable is going to blow their top and basically pop you in the mouth. So, for those who don't know what the fighting words doctrine is, that Foss was referencing there.
Oh, I did have a question for you because you've had schooling. In these opinions, I've read a lot of them since I started the Ninth Circuit channel. I've read a lot of opinions. There seems to be random brackets throughout the opinions that will bracket a word or a single letter, and I cannot figure out why.
That was added after by whoever edited the writing. That's all.
But why?
The brackets just show that that word originally wasn't in the decision.
Okay, that's what I didn't understand because like in this one, A was bracketed. Why?
Yeah. Basically, the judge will write up the decision, and then they'll give it to one of their whoever's clerking for them to write it up, and then basically the clerk edits. And if there's a word missing, they'll put the word in, but they'll put that word in brackets to show that it wasn't in the actual original writing itself.
Okay, that I figured there had to be a reason, so that makes sense.
But you, Gary, got anything?
Probably fell asleep.
No, I'm not asleep. I mean, there's an awful lot going on here, and it's all bad. I mean, but yeah, we're literally universally talking about unnecessary search, at least from what I've been getting as a connecting. connecting thing here. And I mean, the Constitution's Constitution, folks. Got to follow the law.
Mm-hmm. And just him walking away from a group of people did not meet the standard even before Broom. I mean, honestly.
No.
But under Maryland law, since firearms were presumptively illegal, they probably would have got away with it. But it's interesting to see this decision come out of Maryland's court, appellate court, because the judges that sit on this court are appointed by the governor. So if they were appointed any time recently, they would have been appointed by a governor who was very much anti-gun.
What court was this?
The Maryland appellate court.
Oh, I thought it was federal court.
No, this is state.
Yeah, me too.
This is state, Maryland's appellate court. Yeah, this is a Maryland state court that made this ruling.
Well, good for them.
Yeah, that's the surprising part, that the Maryland appellate court made this decision. And the part that is also going to be a factor, even though he was illegally in possession of cocaine, that cocaine that they found on his person, because the initial search was illegal, also makes the search that found the cocaine unconstitutional by virtue of the poison fruit doctrine. So not only is the conviction for that may have resulted from the maybe having the gun illegal, the drug conviction gets tossed as well, because they would never have found the drugs if they hadn't searched him for the gun. That's why the Fourth Amendment's important, folks. As soon as they conduct any search illegally, everything else is also that resulted from that search is also unconstitutionally obtained.
I mean, whether we like it or not, that's the way it ought to work.
Mm-hmm. So, was the guy engaged in a crime? Yep. Would they have known about it without doing the illegal search in the first place? Nope.
One thing you have to keep in mind is a lot of these cases will involve people of bad reputation,
Mm-hmm.
and those are the ones that'll go to the appellate courts. They'll go to the Supreme Court, kind of like with God, what was the one, the wife beater went to Supreme Court? Started with an R. Can't think of his name now. Like Romani or
Something like that.
yeah. I mean, he was a terrible person, and it went there because they pushed it, not so. But the points in the case are what's important, not that person specifically. Is the basis for the appeal was right. He's just a piece of shit. Well, I'm not saying this guy, but just that's how it kind of seems that it tends to be. Rahimi, thank you.
Yeah.
Barbecue. And I will hear some people that can't get past the fact that that's a bad guy. Well, he
Hmm.
still has rights, and that right that he's fighting for, even though you don't like him, that right is your right too. That still needs to be protected.
Yeah, and you gotta remember, like Foss was saying, the people that are going to be adjudicating and having attorneys adjudicate these cases for them are going to be criminals in a
What
large part, because that's who's going to be interacting with law enforcement more often
that's
than not.
you have to have an injury to have standing.
Exactly.
So you can't, like a bad law gets passed, you can't really challenge that law without somebody who is injured by that law.
Yeah, you have to be able to show that it impacts you in a way that violates your rights. And unless you're pulled over and the cop sees a shotgun in your back seat and arrests you for having a shotgun in your back seat, you can't challenge that because it's not directly affecting you until that happens. That's going to be interesting to see if the state appeals this decision to the Maryland Supreme Court and what they have to say on it. Or if the state even will appeal. Because if it goes to the state Supreme Court and the state Supreme Court rules the same way, then they'll have to appeal it to the U.S. Supreme Court until they want to take that chance. Because if they take that chance and the U.S. Supreme Court rules the same way, then it applies to the whole country. Right now, their ruling only applies to Maryland. Other states can, other attorneys in other states who are challenging these types of convictions can use this as a case study in their appeal, but they don't. The state that it happens in doesn't have to. The court that they're appealing to doesn't have to acknowledge it. Whereas if it goes to the Supreme Court, and Supreme Court is in Supreme Court of the United States, and they rule the same way,
Well,
then
that's a huge if.
yeah,
I don't know if there's a plan on why they haven't taken anything lately. If there could be a very good reason, something that they're
mm-hmm.
waiting for to happen. It's just frustrating not knowing. And
Mm-hmm. Yeah, a lot of times in cases like this, they'll just let it die at the appellate court, at the first appellate, and not bother going beyond that to keep it from spreading. There have been numerous cases in the past where that's happened because they figure it's better to cut their losses and just let the case go. Especially in a case like this, where even if they were to try and get it done, to get it overturned, to get the drug, you know, conviction to be upheld, it's not that major of a. Even the drug possession part's not that major of a conviction at this point. The even potentially make it worth their while to appeal it. And the guy only got 5 years. I mean, is that worth their time to try and get reinstated?
it it kind of sounded the the way they described the drugs they found. I It sounded to me like they were trying to somehow push intent to distribute.
Yeah, which, given what he had, Rose, they're basically single doses, each of the little things he had in his pocket. He could have just bought them himself for his own private use. There's no way to tell whether he was going to deal that or not. So, I mean, looking at that, I don't know if it's worth their time to for the prosecutor's office to try to appeal it. Like, okay, we lost this one. Move on. I mean, if it were a bigger crime, like if the guy had committed a murder or something, and then it got tossed because they searched him, found the weapon, and the weapon that they illegally searched him to find would have been the murder weapon, that would be a different situation. But in a minor drug beef, like what this one ultimately is, I'd let it go. I just let it go. I wouldn't even bother trying to appeal it. You've already lost on one appeal. You should have lost the suppression hearing to begin with. So I honestly don't see it worth Maryland's time as the prosecutor's office to appeal this.
Well,
It is Baltimore, though.
frivolity has never stopped the government from pushing
And
ahead.
yeah, and it is Baltimore. So who knows what the hell those idiots are going to do. And this is the same city that's had back-to-back mayors be arrested and convicted of felonies. So, I mean, they're not exactly the most upstanding place to begin with. I was hoping
Like
Kingpin would have jumped on for this one for that
like they
reason.
say, if you're not cheating, you're not trying.
Mm-hmm. This originated in Kingpin's neck of the woods, but he doesn't do shows anymore. But I did send him a link just on the off chance.
I think he's a lot happier not being on YouTube.
Mm-hmm.
That's the impression I got.
Yeah. Oh, I still talk to him. Him and Krabby want to get together and do something like, but with his work schedule, Amy's work schedule, it's hard to get where they're both off on the same day to do anything. All right, I guess I can get that off the screen now.
Is it time for the bracket?
I didn't have one. I wanted to do one, but I didn't have time to put one together.
And I will say for barbecue's bracket, ABBA Gold is probably one of the greatest albums ever assembled. There are no bad songs on that one. I think now they call it ABBA Platinum, but
I'm just not a disco fan. Never was.
You don't have dancing feet or what?
Huh?
what do
You
you
don't
have against Donna Summers? An incredible artist.
It's not my style of music. I mean, I don't like it.
What do you like, Rich?
Mostly listen to rock and metal and some country. Classical every so often.
Kiss?
Motown.
Were you in the Kiss Army?
Officially, no. I never joined the Kiss Army, aka their fan club.
Even Kiss did disco.
And it's probably their worst song. Unless they're playing it live, because they play it live and they play it completely different. I listen to some punk bands too. When I think about it. Actual, real punk music, not the stuff they have now and call it punk. It's not the same.
You should do a real music bracket. Tell us what you think is real music.
I didn't say it wasn't real music. I just said I didn't like it.
I'm not a big fan of opera either, but I can't sit here and deny that it's not excellent music. It obviously is. It takes a great deal of skill and talent to do.
I knew a gal that was she was studying to be an opera singer, and she was pretty good. She was um, somewhat renowned, but she also loved architecture, and she became an architect instead. She designed the first Starbucks in China.
At first, I thought this was going to be one of your snob type stories.
No, no, true story. They sent her over. She started became a architect for Starbucks, designing Starbucks stores, and they sent her over to China to build one over there. Oh, top tip for everyone. Um, Murder is basically a secondary crime federally. Keep that in mind.
Mm-hmm.
So while Rich has been talking, I had on a college baseball game, which went into a weather delay. And so ESPN2, in their infinite wisdom, has switched over to Sunday night rugby. I did not know that there was professional rugby in this country,
Yeah.
but I am watching the Seattle Sea Dragons play against somebody. Rather interesting. I don't understand rugby at all, but it looks like a very rough sport.
Mhm.
Uh, Basically, it's kind of like football ish, but when you pass the ball, you have to pass it underhand and you have to pass it backwards.
Mhm.
You can't pass it forwards. And you can, but you can kick it forwards.
Yeah,
Yep.
but if you get tackled, then one of your teammates can pick up the ball and start passing it again, which is kind of
Yeah.
weird.
That I don't under. I am not an not average, avid viewer, so I don't know all the rules.
Yeah.
And then I might be mixing some up with Australian rules football, which I watched more.
Well, Australian rules football is based on rugby, so they they combined a little bit more American football with rugby. They come up with Australian rules football, and it's absolutely insane.
It's fun to watch.
Uh huh.
I don't know how these guys keep from being carried off the field in an ambulance with some of these collisions and stuff like that, and
Hmm.
blood coming out of their heads and stuff
Oh
like.
yeah.
They do hit hard, but actually, football players hit with more force, but they're padded.
Hmm. The good rugby's during the Olympics when you get all the national teams going after it.
Well, the
You
fun
get
stuff to watch is women's rugby.
Yes, women's rugby, women's hockey.
women's
Women's
hockey
hockey
is,
is surprisingly very good.
yes, it's a much more skill based game than what men's hockey is. I mean, the passing in women's hockey is ridiculous. How spot on and accurate their ability to pass that puck around is crazy.
Here's another thing they're doing, this scrum thing where there's about 20 of them with their arms all interlocked with each
Hmm.
other. I haven't figured that out either. But Foss will be glad to know Seattle is winning. Actually, it probably already happened. It's probably a delayed. It's in a daylight, so yeah, it's not live. Well, at least I don't think so. It could still be daylight there.
No, women's basketball just plain sucks. Comparing women's hockey and women's basketball are not the same. Women's hockey is a much faster, more skill based game. Not as nowhere near as much hitting.
Women's college basketball is all right. Women's professional basketball is terrible to watch.
Women won't watch women's basketball.
Mm-mm. Vulcan Rumble out there on the YouTube side. saying he's all caught up.
I can't wait until this next year. Kansas State high schools are going to start allowing girls touch football. It should be interesting.
Heck, flag football is going to be an Olympic sport at the next summer games. So.
I think they've tried to do that before. I think as one of the I can't think of the term for it, but
Demonstration sports.
Yeah.
Mm-hmm. I forget who was saying it, but Tom Brady supposedly tried out for the flag football team. That they were trying to get some former NFL players involved.
You could
Barbecue?
play.
Who, me?
Mm-hmm.
Nuh-uh. Barbecue, nothing will get me to watch women's basketball. I don't watch basketball, period. So, according to Vulcan Rumble, there was a knife attack at Penn Station in New York. There's been a lot of that going around lately. People attacking people with knives on subways.
Oh, as far as I'm concerned, that's a local New York story. I don't need to know about it.
It's amazing all these places that have banned guns in an effort to lessen violent crime, that criminals just turn to other weapons. I mean, who'd have thought, you know?
Well, they don't even turn to other weapons. They still have guns.
Mm-hmm. And a couple of these attacks were in Atlanta on their subway system, where I forget what they call it. There have been multiple women attacked by different people with knives on the trains there.
Speaking of women, Minnie Wayne's out there says happy 6/7. So if Misty's out there, yeah.
Yeah.
It is
Bonsai, Mini
6/7,
Wayne.
by the way.
Yeah. That'll probably freak Miss out if she shows up. I just made Mini Wayne a moderator. That'll freak out Misty if she shows up. What else we got going on? There's 4 new entries going to be coming into the country as far as mid-sized trucks are concerned, besides the ones we've already talked about on the channel. Mitsubishi is going to be doing one based on, but it's actually going to be a renamed Nissan Frontier. And then
I would not. I have owned a Mitsubishi. I would not own another one because all the dealerships disappeared.
Mm-hmm. Yeah. The other one, two other ones are going to be Hyundai/Kia. And I forget what the fourth one is. So you're gonna have Ram back in the fold with the Dakota. That's a new one, but I don't think that was one of the ones that the guy was counting in the video I watched. Damn it, I don't remember who that fourth one is though. Canada's going to be getting the Chinese trucks that we can't get. Honda has temporarily stopped production on the Ridgeline.
Really?
Yep, apparently they're doing a complete redo of it and stopped production until like 2028, 2029, something like that.
So what about the Passport and the Pilot? 'Cause
I
those
don't
are
know.
built on that frame,
Yeah, I know. I don't know. I haven't heard anything about those, just the Ridgeline.
and they are the same from the bill B pillar forward.
Mm-hmm.
All three of them are exactly the same.
Yeah. Yeah, similar to how the Maverick, the Bronco Sport, and the Escape are based off the same platform. But yeah, I haven't heard anything about the SUVs, just the Ridgeline. That they're revamping the entire thing.
I kind of agree with Pack Rat. I hate CVTs. I've had the
Mm,
CV. The one in my wife's Civic is a 2016 Civic, has a CVT, and you can't tell it's a CVT. The one I had in my Mitsubishi, I hated that thing.
yeah.
I had an Outlander. I liked the Outlander. It was they were built. Mine, God, what year? Mine was built on an Evo 7 chassis, but that transmission was horrible. It's like having turbo lag in a transmission.
Yeah, there's two different kinds of CVTs. One's good and one's bad. I just don't remember what the designation. There's one's electronic and one's not, or something like that. That's the difference. And the one's good and one's bad. I just don't remember which one's which.
I had a CVT in my Nissan Versa. It's great until it's not.
I mean, the principle behind it is
Concept's
great.
great. Hmm.
Unlimited gearing,
Mm-hmm.
but uh, I I will not own another one. What?
Now, Ron Wayne's out there now. He says his last Frontier had 300,000 miles. He'd, he'd be glad to get another one. Yeah, the thing with the Frontier is they're still putting naturally aspirated V6s in those things. No turbos or anything. So if
I won't
you're,
buy a turbo either.
yeah, I was going to say, if you're one of those people that doesn't like the turbos and you want to get a midsize, that's pretty much the only one you're going to be able to get. because all the other ones were all turbo. I think the Ridgeline isn't a turbo, but again, they stopped making them for the time being. So
It shouldn't be. My Passport's not.
yeah, it's a naturally aspirated V6 in the Ridgeline.
And they're decent. Mine's 2021, and it's like 289 horse.
Mm-hmm.
So it's got good enough beef to it.
Yeah, it depends on whether you want unibody or body on frame. If you want body on frame, get the Nissan. If you don't mind the unibody, get the Ridgeline if you can find one at this point. I think it's nice about the Ridgeline is it has that trunk. So not only do you have the bed, but you also have the space underneath. And the tailgate opens two different ways. You can open it like a door, or you can open it like a traditional tailgate. Was it your show on Wednesday, Gary, or was it on Barbecues where we were talking about the new Ford Ranchero?
I'm not sure, to tell you the truth.
Is it going to be as ugly as the original?
No, it just looks like a small pickup.
Oh, I will say the original Ranchero, the one that based on the Falcon,
Mm-hmm.
those look cool. But when they started getting big, they're just god awful ugly.
Yeah. No, the new one's going to be smaller than the Maverick. It's only going to be a two-door. Yeah. Base engine's going to be a 3-cylinder.
Are they competing with like the Santa Cruz?
No, because the Hyundai's not even doing the Santa Cruz anymore.
Oh, really?
Yeah. They stopped production because they weren't selling enough of them.
I thought they were neat little vehicles. I got to see Defense Dads.
Mm-hmm.
It reminded me a lot of the old Subaru Brats without the seat in the back.
Mm-hmm. Yeah, they stopped production of those and started developing a mid-sized truck instead. But they were getting their butts kicked by the Maverick in sales, so it was like, yeah, not worth their time to do it, I guess. Which makes me wonder how the Rampage is going to do sales-wise.
I don't know. Trucks are just so god awful expensive right now. I have to think that truck market's going to collapse.
Yeah. Well, the Rampage is not the Rampage. The Ranchero is supposed to start at 19,000. See how long that lasts. Remember, that's what the starting price for the Maverick was supposed to be, was 20,000.
I think it's gonna be a tough sell for a 3-cylinder in a pickup truck.
Yeah, it's got a 3-cylinder. Then it's going to have an optional hybrid 4-cylinder, and then turbo 4-cylinder.
What was it? The Geo Metro was a 3-cylinder.
The Ford Festiva was a 3,
Well,
but both the Metro and the Fiesta ended up with 4-cylinders by the time they stopped production. Those Metro, the convertible version, those things were quick for a small little car like they were. They were super light. There was a car chase in Pittsburgh. One was being chased on Interstate 279 northbound by a bunch of city cops and state troopers doing 160 on the interstate. I didn't think they would be able to go that fast. But you could listen to them on. I was listening to them on my father's scanner. I was staying over at his house on the weekend when that happened. Just listening to the cops trying to stop this Geo Metro convertible.
anyway, it says it wants a Yugo. Unfortunately, the country went out of business.
Yeah.
I think a Suzuki Samurai would be better for him anyway.
Mm-hmm. What the hell was the Geo version of it?
I don't know.
Geo
What was the
Tracker or
Isuzu
something?
one?
Was the Zuzu the Tracker?
I think it might have been.
Whoa. Welcome Rumble says, can you ask a question about shotgun prices where we are? He said in Massachusetts they're used as an alternative to an AR. And unfortunately the units that they're supposed to sell for under 1,000 are now going for $2,000. Jesus Christ. No, here shotguns are cheap.
I don't know. I haven't looked lately.
Mm-hmm. You can get a good Mossberg, either a 500 or a Maverick for 300 or less. The Turkish shotguns, you can get them for under 200. So, yeah.
Yeah, I'm looking at the shop that I used to go to before Skagit Valley Guns. They've got Maverick 88 Security, 20-inch for. Can I say the price? I don't want to get you in trouble.
I don't know. I've said prices and haven't gotten popped. But,
287.
it's not bad.
Yeah, the prices look about what I remember them being.
Mm-hmm.
Nothing crazy. Yeah, Mossberg 590 retrograde for 6.
Ooh, that's a good price on that. I've seen those go for up to 750. Yeah, buy online and have it shipped to your FFL, like Pack Rat said. You can find places online that are going to have them cheaper. Problem with online is you can't check them out before you buy them.
Well, hopefully the uh, gun shops don't have a high rate.
Mm-hmm.
Some the place I used to go, I think it was $50. It used to be like 25. Kind of 25, a wink and a nod, and it was all good.
Mm-hmm. They're saying Bretta A300 is $1,200. 1304 is 1,800. Said they were 700 before the job.
Well, let's see what we come up with here. Beretta A300 for 11.
So that's about right then.
Or there's a couple different ones.
Mm-hmm.
The Ultima Patrol, that's the 1100. The Ultima is 9. It's a little less tactical.
Mm-hmm. He's in Massachusetts, so you might be talking about the little less tactical. I don't know. But Brettas are usually at the higher cost than some other brands anyway. Depending on what model. What you're looking for, whether you want semi-auto or pump action. Ron Wayne's out there wanting to build a Kirk special. It says bamboo, sulfur, diamonds, and coal. Save your dough.
Well, you need twine too.
Yeah, don't forget the twine. Night, Ron. 2A.
He was talking about a little earlier a 67 Mustang, the 302.
Mm-hmm.
In high school, I was sweet on a girl that drove a 67 Fastback with the 351.
Nice.
That thing was stinking fast.
Mm-hmm.
She let me drive it one time after school, and I accidentally lit it up across an intersection. So I, not even didn't even put the pedal halfway down, and it just lit them up. That's the that's the one where I went to prom with her best friend, and we never talked again.
Ron Wayne says, did you say 6'7"? I still can't remember what the hell that other mid-size coming is.
Oh, Round's bringing back the Dakota.
Yeah, I already said that.
Did you? Oh, I don't listen.
Yeah. People are speculating. Oh, maybe they'll put a V8 in it. I don't know if they're going to do that.
Well, Google's saying Ram Dakota, Ford's next gen EV truck, Mitsubishi, and next generation Nissan Frontier.
Yeah, but those are all ones that are already announced. This I believe was a foreign one, so I'm trying to remember what it was. The Ford EV is going to be an EV Ranger. I think they're calling it the Ranger Lightning, like they did the F-150 Lightning. Remember back in the day when the F-150 Lightning was a street rod? Pickup back in the early 90s?
Well, yeah, because there was the Lightning, and what was the other Ford pickup?
Well, you had the Lightning from Ford and you had the Typhoon from GM and Chevy.
Yeah.
I think Ford had one that was an SUV version too, based on the Bronco, but I don't remember what that one was called.
Well, they had the Sport Track, which was a kind of a mid-sized four-door pickup-looking thing, but it was classified as an SUV, I believe. I was kind of looking at those at one time.
And GM had the Cyclone too, which was an SUV. They had the Typhoon and Cyclone.
I'm only seeing for foreign cars, Mitsubishi, Hyundai. Oh, maybe Tata's going to make a pickup truck, compressed air pickup truck.
Yeah, Hyundai and Kia are both supposed to have one. Same truck, probably different badges. Like everything else, Hyundai and Kia anymore.
Will they be as easy to steal?
I don't know.
I had a friend that he has a Kia, um, and Kia gave him the club to put on his steering wheel. That was their solution. Oh, when I was doing jury duty, one of the other jurors, he had one of the hybrid Jeeps, which he loved. For his kind of his normal driving, commuting driving, he said, I forget if like 50 miles or it's like 500 miles on a tank, I think. But if he was doing long range trips, then it would drop significantly.
Oh yeah, I just went and looked up the video. I saw it. Yeah, it was Ram they were talking about. Okay, so it was the Dakota. Was the fourth one. You got the Mitsubishi, the Hyundai, and the Kia were basically the ones that I hadn't seen anything about yet. So. And the Mitsubishi, that's just going to be a rebadged Nissan Frontier. Yeah, Packrat says the Sport Track was based on the Explorer. Yeah, and that's the same size as the Maverick. So, there's my mother-in-law's neighbor has one still. And it's the exact same size as the Maverick.
I don't know because I had thought about getting one, but then looking at Consumer Reports, it got terrible ratings for like handling and rollover.
Mm-hmm. Yeah, they didn't sell a lot of those. They were basically competing with themselves because they still had the Ranger at that point.
One of the greatest platforms ever made. The Ranger.
Packrat say he thinks Jeep is coming out of the new truck. Yeah, they are. The Wrangler Rambler or Scrambler or something like that. Something along those lines. Basically a two-door version of the Gladiator. Only it's going to have the
Scramblers.
old... Okay.
I think you're saying what I was going to say.
It's going to have the old school shark nose on it.
Yeah, because the Scrambler used to be a Jeep truck.
Yeah. The Gladiator, I think they're making that officially a Wrangler too. The Wrangler Gladiator. I think both it and the Scrambler are gonna have the shark nose to differentiate them from the standard Wrangler. According to one video I was watching.
I kind of wanted one of those. Because, I mean, when you need a pickup truck, there's nothing better than a pickup truck. But I rarely need a pickup truck.
Mm-hmm.
So I went with an SUV.
That's what's nice about the Maverick. It's pickup truck, but it handles like an SUV.
Well, I wanted more enclosed space.
Mm-hmm. And since she's the one driving it, it's like it's either the Ranger or the Maverick. Ranger or Maverick. It's like she's gonna be the one driving. She's already got an Escape. She likes that. This is gonna handle similar to the Escape. We'll get the Maverick. That's basically what it came down to between getting the Maverick or the Ranger. And Maverick actually has more interior space than the Ranger does. You got more back seat room in the Maverick than the Ranger.
I'm going to jump out.
Okay.
So,
Yeah.
Gary,
you want?
you have a good night. Well, I got a video coming out in the morning. It's about putting a scope on a Henry Golden Boy.
Uh-huh.
Fancy.
Nice.
Yeah. So, well, everybody have a good night.
Yep.
Yep.
See you later. Jumping on. Wayne says he's got to have a truck for work and range. Yeah, she kept talking about she wanted a small truck, and when they came out with the Maverick, it's like, she wanted to wait till till she had the Escape paid down more, so that she got more trade-in value on it. And when hit a certain point, she's like, "Yeah, let's do it." I'm like, okay. And for what she needs, she doesn't need something that's going to tow more than 4,000 pounds anyway. So that's the main difference between the Ranger and the Maverick at this point. It's tow rate. They both have the same onboard load. They both can take up to 1,500 pounds in the bed. So main difference is 4,000 or 6,000 pounds towing. And to be honest with you, we've had that loaded on with a trailer that was towing 5,000, and it didn't hesitate to pull that weight. So no issues. I think Ford's being conservative with the 4,000 pound weight rating on the 4K tow package, to be honest. Does that mean I'm telling you to go out there and tow 5,000 pounds with a Ford Maverick? No. Especially if you don't have the 4K tow package. Because without the 4K tow package, it's only rated at 2,000 pounds towing. I think we could probably start wrapping this up. Got anything you want to plug or anything, Gary?
If anybody wants to, I got a show tomorrow night on Gizzard Gary channel. It's at 9 o'clock p.m. Central. It's called Foul Territory. Love to have everybody there. And thanks for having me.
Yep, no problem. And I want to thank everybody who watched, whether you're on YouTube, Rumble, or X. And we'll catch y'all tomorrow night, hopefully. Till then, we will bid you all adieu and catch y'all later.